What up guys, Fast Eddie here, and this is going to be a more serious video. I'm not sure how serious I can be looking at retards like this, but I'm going to try. So this is going to be a review of the decision by Riverside County to not prosecute David Macek, who's more commonly known as the Tagalong Predator, who showed up along with Sebastian Rodriguez. So this video is basically going to outline whether we agree with the decision of the state to do that or not, and consider some additional thoughts as well. So let's just get right down to the chat. Although the video is going to focus more on Macek's guilt or innocence, in order to do that properly, we'd have to examine the entirety of the case. So we'll begin by first looking at the chat log. Okay, so yeah, right there. So the third line in the chat, and then the decoy has identified as a 12-year-old female. So immediately we can see that these guys are sick. These guys are going for a female that is probably prepubescent, and that's disturbing. So I think that really makes this a severe incident. So it adds a lot of gravity to the chat and to the actions. So I think that warrants, the age warrants a harsher sentence just right off the bat. These guys really deserve to get the book thrown at them. Okay, so I'm just gonna kind of go through it. So he identifies as 16. Sawi, you can buy beer. Yeah, fucking typical decoy bullshit. Right, and then so yeah, the decoy wants older male. The decoy, of course, is, dude, I'm looking for older. So then he finally says, yeah, okay, I'm a 20-year-old male. Yeah. You know, I'm not, this seems like it's just a bunch of bullshit. The chat between Sebastian and the decoy is basically just bullshit. I know at some point yeah, see, you can mic. So there's some discussion of bringing mics. Let's see. So they're already calling each other babe. That's disgusting. Okay, so you can't bring me mics. And I know there's Coronas. Our way lived there. Okay, so they're talking. This is a pretty brief chat log. There's not too much. Okay, so yeah, it was just a regular chat, not really talking about too much. Basically, the decoy bringing him over pretty quick. So let's look. Okay, so here we have one of his more current RSO pictures. Sebastian Rodriguez, he's living in Sun Valley, age 27. Really fat. He got pretty fat. This guy's definitely, he's not aged very well. And then the crime that he got. So attempted lewd or lascivious acts with a child under 14 years of age. That's a serious charge. His was attempted, of course, because it was a sting. It did not, in fact, happen in real life. But since he was charged with this crime, I think that it's reasonable to question whether Macek was guilty of the same crime as well, seeing as he showed up to the house, etc. So first, in order to see whether Macek is guilty of this crime, we're gonna have to understand what attempted means in a legal sense. So here we go, of course, to Wikipedia for a brief answer. So attempt. An attempt to commit a crime occurs if a criminal has intent to commit a crime and takes a substantial step towards completing the crime, but for reasons not intended by the criminal, the final resulting crime does not occur. Yeah, so it's wanting to do something or trying and then not. Okay. Attempt to commit a particular crime is a crime usually considered to be the same or lesser gravity as the particular crime attempted. Attempt is a type of inchoate crime, a crime that is not fully developed. The crime of attempt has two elements. This is crucial. The crime of attempt has two elements: intent and some conduct toward completion of the crime. So let's see this. Resource defining attempt. Okay, so that's from Duke Law School. That's a good citation. So I'm fairly confident that we can agree and conclude that that in fact that is an accurate citation. So that attempt has two elements, and those two elements are intent and some conduct towards the completion of the crime. So now that we've gone over the background, let's consider through the evidence whether Macek should have been charged. So the first argument I'd like to make as to why he should be charged is his presence. He showed up. If he wouldn't have showed up to the house, he would not have been on the show. He would not have been in the situation. So I think that Macek's very presence is enough to open the door for speculation of guilt and for us to establish guilt. Just the fact that he was there, that certainly makes him culpable, or that raises the question of whether he's culpable. The second thing I'd like to point out is that they each showed up and Sebastian brought mics. So since Sebastian is 20 years old, Macek is 22. From that, it is very safe to conclude that Macek purchased the alcohol. So look, let's watch.
She asks about bringing Mike's Hard Lemonade.
Yeah, I did.
What is this?
Mike's Hard Lemonade.
So that's okay to bring that to a 12-year-old girl?
No, it's not okay, sir. I'm not even aged to smoke myself.
I will, babe. We can eat at your house. I know where Corona is. It's only an hour.
See, so, I mean, you right away. So since Sebastian is only 20 years old and Macek is 22, the alcohol most likely came from Macek. I'm imagining that it might not, and we can't prove that Macek did, but I think that it is reasonable to assume that he did because he is there. And the presumption that he's guilty is supported by the next thing I'd like to point out. So the next thing I'd like to point out is that Macek knew specific details about the incident. He knew specific details about the decoy. So to prove that, let's go here.
Sir, I'm so sorry. I don't know what to say. I don't want to go to jail.
What would have happened if I wasn't here and a 12-year-old girl was here?
Nothing, so I wouldn't have done anything with her.
How come you brought your tag along?
Because I just brought him because I wasn't going to do anything, sir. I just wanted him to come with me. I really wasn't planning on doing anything, sir. I just wanted to come stay.
Well, the other option would have been that the two of you had some sort of plan cooked up.
No, sir.
She said she was alone, so.
So right there, it was that last part right there. Let's review. It's where Macek responds when Chris says, "Well, you guys could have had something cooked up."
Nothing, so I wouldn't have done anything with her.
How come you brought your tag along?
Because I just brought him because I wasn't going to do anything, sir. I just wanted him to come with me. I really wasn't planning on doing anything, sir. I just wanted to come stay.
Well, the other option would have been that the two of you had some sort of plan cooked up.
So it's right here.
No, sir.
She said she was alone, so.
So Macek says, she said she was alone, so Chris points out the very obvious, that it's reasonable to assume that they were both going to engage in sex with the decoy. They were both going to engage in this felony. And then Macek's response to that accusation is, no, because the decoy said she was alone. That makes no fucking sense. The only way that these guys would be able to commit this felony was if the decoy was alone. So to say, no, the decoy was alone, therefore I wouldn't commit this felony, is bullshit. So he knew that the decoy was alone. Macek knew the decoy was alone. The decoy told that to Rodriguez. So Mayhek communicated with Rodriguez to some extent about what occurred in the chat. So based on their communication about what occurred in the chat, I think it is reasonable to assume that Sebastian had also told Mayhek about the age as well. Since Sebastian relayed that the decoy would be alone, I think it's reasonable to assume that he would tell the decoy that as well. And if we consider that, and if we assume that, then the conclusion is that he's likely guilty. Is that he's likely guilty. But of course, in a court of law, in the American political system, guilt isn't determined by what is right or by what should be. Guilt is often determined by precedent and pretty much, yeah, primarily through precedent, through rulings that have previously occurred. So I imagine that yeah, let's consider. So that's basically everything, all of the information about the case so far. So let's consider and then conclude as to whether we agree with the decision of Riverside County to not charge. So I think that it's safe to assume that he knew that the decoy, Mayhek knew that the decoy identified as a 12-year-old female, and I think it's safe to assume that Sebastian told him. However, the presumption of innocence is one of the fundamentals of it's one of the fundamental principles of the American criminal justice system, right? So all people technically have the presumption of innocence, and I know oftentimes in practice that's not really the case. Is the overwhelming amount of people who are charged with crimes oftentimes just accept and plead out, but ideally, so he would have the presumption of innocence. So it would be the duty of the prosecutor or the duty of whoever was charging Mayhek to prove that he knew the decoy was underage. And so far, there's nothing that proves that he knew the age of the decoy, even though it is very safe to assume that he most certainly fucking knew. There's nothing so far that is proven absolutely, beyond a shadow of a doubt, that he in fact knew. So I think based off of that, I don't think that he would be found guilty. And I don't think that I don't think that there was any way that a judge or that a jury would have been able to prosecute him, especially if the defense attorney was doing their job, was even halfway doing their job. So then we'd also have to consider whether, if Mayhek was charged, so perhaps they considered whether he has the kind of money to hire an attorney, or whether he doesn't have that kind of money as well. And well, there's no way that we'd be able to know that. But yeah, I don't think that he would be able to. I don't think that there's enough to convict him. I think that ultimately I agree with the decision of Riverside to not charge Mayhek, even though he probably did it. I don't think that there was enough to convict him. He's certainly a fucker. And I think that this guy is ethically guilty. He really fucked up. But I think that more so than punishing one person, it's important to protect people who are really innocent. So one of the famous Supreme Court justices, I believe, said it's better for 100 innocent men to go free than for one innocent man to sit in prison. And I think that's I agree with the sentiment of that. I think that the greater injustice, because it's an injustice. For this motherfucker to walk out of here and not be charged is an injustice. I acknowledge that. But the greater injustice would be if he and other people, were convicted for flimsy evidence. Because the evidence here against him is flimsy. So if American courts and if people as a whole begun being prosecuted for such flimsy evidence, I think that that would be the greater injustice. I think that that is that would that's something that is far worse than a few people who are probably guilty but not technically guilty to walk free. So leave a comment, tell me whether you agree or disagree or whatever, and all right, guys, until next time.